Good morning. The first case to come before the court today is Benjamin Enger et al. V. Patrick Black. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know as I'll be keeping track of the time. Would you like to reserve time for rebuttal?
I would, John. I'd like to reserve 5 minutes, please.
Very well. The arguments are being recorded, so please stay behind the podium and keep your voices up. Please do not use the names of minors or victims in the course of your arguments, and you can refer to people by their initials in the instance that is relevant to your case. Initials are terms like the child that are generic terms. The judges have read your briefs, and we are ready to proceed when you are.
Please, the court. My name is Craig Reynolds. I represent Benjamin and Kelly Enger. I think all the parties in this case are adults. This case involved the purchase of a home and discovering that the home had a contaminated water source. Mr. and Mrs. Kelly moved to Ohio in 2020 and came to Wayne County for employment and purchased their first home. They personally visited the property. They reviewed the residential property disclosure form prepared by the homeowner. They obtained a home inspection report, including a water test for the flow and presence of bacteria, and they decided to purchase the home. They moved into the home, and shortly after moving in, they learned that not only was the water well at their property contaminated, but the groundwater in the neighborhood was contaminated. They learned that the homeowner that sold them the home and filled out the disclosure form was aware of the contamination, and they filed suit against him for the false statement that the homeowner made in the residential property disclosure form, saying that he was not aware of any material problem with the water supply system or the quality of the water. The homeowner moved for summary judgment, and initially the trial court denied that summary judgment request, and on a motion for reconsideration, the trial court granted the request. And the trial court held specifically that it's undisputed that the defendant never made any representations or statements of any kind to the plaintiff concerning the well or the water quality. And the trial court went on to state that the plaintiffs couldn't have relied on any statements or representations made to them because the homeowner didn't make any statements or representations to them. And we certainly dispute that finding. I think it was wrong to say it's not disputed. It is disputed. The homeowners filled out a residential property disclosure form. The first line of that form, the very first line says, "This is a statement of certain conditions and information concerning the property actually known by the owner." So to say that the homeowner completing a statement isn't a statement, it goes against all common sense and logic.
Counsel, then would you say that any time, because this is an as-is situation as well, would you say any time the seller of a home fills out, completes the disclosure form, that anything on there would constitute an affirmative representation?
If they fill out something falsely that they know to be false, yes. I think that if they answer no when the answer is yes, or they answer yes when the answer should be no, if they falsely represent on that form, the case law does not allow them to hide behind an as-is argument. The Ohio Revised Code imposes statutory duty on the homeowner to fill that form out completely and disclose material defects within their knowledge. If they don't know about it, they don't have to disclose it. But when they do know about it and they're asked a question, they have to disclose it. The Ohio Revised Code requires the homeowner to fill that out in good faith. very first question on the form says, do you know of any material problems with the water supply system or the quality of water? The homeowner looked at that question, had a choice to not answer it, had a choice to not fill out the form. He filled out the form and he answered no. I'm not aware of anything. And as discovery disclosed, the homeowner had been aware of problems with his water supply for over 20 years. He complained to the Ohio Department of Natural Resources in 1997, in 1998, and in 2007. He was advised that the contaminant level in his water for barium exceeded the maximum contaminant level of the Safe Drinking Water Act. He was advised by the Wayne County Health Department not to drink the water. He went to a meeting where he was informed, and he testified under oath, that the ODNR advised them that there was something in the neighborhood contaminating the water, and the ODNR was trying to identify the source. So this isn't where he might have suspected but not known. He knew. He knew, and he falsely answered no. And for the court to say that the Engers didn't rely on that representation is also wrong. Mr. Enger testified that he got the form and he relied on it. He relied on the disclosure that the homeowner wasn't aware of any problems.
What did the inspection show about the water? You indicated.
What's that?
What did the inspection report that was done show about the water?
A routine report shows that the flow of the water was sufficient, the gallons per second, I think, report, and that there was no bacteria. The things that are done in a routine test. Routine homeowner tests do not test for oil well contaminants. There was a test done, and the court also found that the plaintiffs failed to have the well inspected, which was not correct. The plaintiffs had the well inspected. They didn't have it inspected for oil and gas contaminants because the homeowner didn't tell them that those contaminants were in the well, even though he knew they were there. The 12th District Court, in a Brewer case involving electrical issues, said that where the settler has superior knowledge about the condition of their property, once he makes a misrepresentation, the buyer's duty to inspect further terminates. So once the seller told them that I knew this, or I don't have any knowledge of any problems with the well, when he knew there were problems, their duty to inspect further terminates. The court seemed to hold that if there were representations, there were open and obvious problems. And I don't know that there's any evidence to support that finding. Contaminants in water are not visible to the naked eye. The contaminants that were ultimately discovered were not found by the water testing supply, the company that tested the water source as part of the transaction. They certainly weren't discovered by the homeowners until they lived there and they asked around the neighborhood.
And they had some kind of system that was supposed to clean the water, I understand, as part of the home purchase?
After learning that they were not to drink the water, the homeowners installed a reverse osmosis system for a single tap at their kitchen sink. Didn't affect any of the other...
Did the inspection say what the purpose of that Vertox system was?
No.
And why it was there?
No, just said it was there.
It did. Did it say it was operating appropriately in the inspection report? Do you recall?
I don't even think that was...
You don't
I
recall?
don't know. I don't know. I don't want to misspeak on
fair.
that issue, Your Honor. But it certainly didn't treat all the water in the house from the various faucets. Your Honor, I think the trial court made a mistake when they found that there were no statements being made by the property owner. Clearly, that residential property disclosure form is a statement. It says in its first sentence, this is a statement. And so for the trial court to conclude that no statements were made, it flies in the face of reason and the law. It was a statement. And there is a huge issue of fact of what should a reasonable test disclose. I don't know. But there's no case law that says contaminations known to the homeowner but not disclosed are easily discoverable. I can't find a case in Ohio that rules that way. For that reason, I think this case needs to be reversed and remanded to the trial court for a trial on the merits. Thank you.
Thank you, counsel. You'll have your full 5 minutes for rebuttal.
May it please the court, my name is Joshua Farrell. I represent Patrick Black, the appellee in this matter. The humorist Carl Sandburg said, "If the facts are against you, argue the law. If the law is against you, argue the facts. If the law and the facts are against you, pound the table and scream like hell." Mr. Reynolds' disposition and restraint are such that he would not engage in any pounding of the table or yelling at today's argument. But make no mistake, Mr. Reynolds' client's position is without the support of both the law and the facts. As such, the trial court correctly determined that the appellant's claim for fraud was legally unsustainable and appropriately granted summary judgment in favor of Mr. Black.
I want to make sure as to what you're arguing and what you're not arguing. You're not arguing that a homeowner seller can just fraudulently write anything on a non-disclosure form and sell something as is and say, that's too bad then.
It's a very different factual scenario than would exist here.
Well, sometimes we look at just what issues of law are going to arise out of factual situations.
I would not make that argument. I think that that would be a different case. And
Well, what was not fraudulent here?
So there was no representations or statements made. Only a box that says no was checked.
So let me stop you for a second. I'll put it in like easy terms for me to understand, okay? So if you ask your husband, is he having an affair with your best friend, and he says no, that's not a fraudulent misrepresentation?
Very different situation, I would state, Your Honor.
That's why I presented to you, though, to get it down to the nitty-gritty sometimes.
The key here is, I guess, in that situation, if there was a separate written contract that said that this marriage will continue as is, and Ohio law was clear that in the presence of an as-is clause, checking a box no on a property non-disclosure form cannot constitute a fraudulent misrepresentation. It is non-disclosure at that point.
Excuse me, counsel. So what is the disclosure form for?
The disclosure form is for the buyer, to the best of his or her knowledge, to identify certain parts of the property that are identified there, and to the best of their knowledge, they would identify if there are any issues of which they're aware. And I may add, we can test that this water is contaminated, and I'll get into that in a second, if I may. But that's the purpose of it. However, case after case, cited not only by Mr. Black, but also by the appellants, make very clear that when there is an as-is clause in a real estate contract, representations made, like checking the box no, cannot be relied upon by the buyer because they have the opportunity to inspect. And a water well could have been inspected, just as the Engers admitted in their deposition. They could have done that. They elected not to do so.
Counsel, can you explain to me why the case that was referenced by opposing counsel related to the electrical issue is not on point here?
I pulled that case because I assumed that that question was coming. Mm-hmm. Here's what that case says. And unfortunately, this follows a pattern of cases cited by the appellants before this court that doesn't provide the whole picture as to what is going on. In that Brewer case, the court says, In a similar vein, courts have concluded that the buyer's duty to inspect the premises to discover defects terminates when representations are made with respect to a material fact in response to a buyer's direct inquiry. In that case, the seller of the property was asked directly by the buyer if there were any electrical issues.
Isn't there a statutory duty to disclose on these forms?
It is to fill that form out in good faith, Your Honor. However, Ohio law, under Ohio law, decades and decades of well-established case law state the following. As is clause in real estate sales contracts relieve the seller of any duty to disclose defects associated with the property and places the risk upon the buyer as to the existence of defects. As such, the existence of an as-is clause bars claims for fraud based on passive non-disclosure. Case after case cited before this court by both parties reinforce that a seller's response of no to a question on a residential property disclosure form constitutes passive non-disclosure. Every case we cite, the only ones in which the Court of Appeals does not affirm the trial court summary judgment is when there is some subsequent act by the seller of the property, either a fraudulent misrepresentation when directly asked by the buyer about an electrical issue or some other issue, and they misstate that reality, or if the seller takes some type of step to conceal, fraudulent concealment of a defect that could not then be discovered through an inspection.
So counsel, it doesn't matter if that potential issue is a latent issue?
It does not.
It doesn't matter.
It relieves the seller of any duty to disclose risks associated with the property, and it places that risk solely on the seller due to the seller's ability to inspect the premises prior to their purchase of the same.
So what did that add? I mean, here we have the seller did an inspection, did I'll call it a routine inspection, if you will. They checked the water, in fact. But they had to do something here that was beyond that to inspect the well. It was some special inspection that you say they should have done. What did that duty end on the seller department responsibility? They got to test every system in the home on special tests. And your client can put whatever they want and no on the disclosure form. And too bad for you.
If they have the ability to inspect, which they certainly did here, just like the court in Whitfoth held that, and that was a yield issue with a water well. But a water well, the Engers were aware that this property, the water supply was supplied through a water well. They tested the water well. They didn't perform a test to check on the quality of the water. They could have done that. I asked Mr. Enger in his deposition, could you have done that? And he said yes. Should you have done it? He said yes.
Counsel, when you say they didn't check the condition, I don't know that that's necessarily accurate, because they did check it for bacterial or any kind of, something that made it impure, not able to be safe drinking water for that.
I dispute some of that, Your Honor. First of all, we certainly contest the assertion that this water is contaminated. My clients lived on this property for 30 years, okay? They drank the water. They used the water to bathe, to wash clothes, to wash dishes. Their use of the water was routine, as would be expected from any homeowner. And this makes sense because the elevated levels of the substances of which the appellants complain pose no threat to human health, a reality that was confirmed by the Ohio Department of Natural Resources in 2007, which characterized these elevated levels purely as aesthetic in nature.
Well, why did the health department notify them not to drink the water?
I don't believe that that's accurate. Directly from the well, yes, they shouldn't go out with a pail and drink directly from the well. That's why they had a water softener installed, as well as a reverse osmosis system installed. And the difference is the appellants complain of the test that came directly from the water well that shows these elevated levels beyond what the ODNR showed in 2007, because those tests were taken after the water passed through either the water softener or the water softener and the reverse osmosis system, which is how the water was used in the house.
Well, one of the statements you made earlier was they had no idea and they did not believe what they were being told about the condition of the water with the barium, but yet they did install different mechanisms to try to purify that water.
They did. I have the same systems in my home, Your Honor. I think it's very routine for homeowners to do that, to try to improve the quality of their home. And so they were aware that there were some issues with the water. They were never told, don't drink it after it comes through the water softener or the reverse osmosis system. And that's how the water was used in the home. They used it that way for 30 years. So the purported contamination is not something that we accept. And frankly, we can test that assertion. But even if it is contaminated, it doesn't matter. Because Ohio law, again, makes very clear that the presence of the as-is clause puts all of the risk on a defect on the buyer who has the right to perform an inspection.
Counsel, I thought I heard you earlier, so I want a little clarification, say that there was a requirement on the seller when they're filling out that disclosure form to do so in good faith.
Correct.
Correct? Okay, so why isn't that a question of fact for the jury to determine whether that representation was made fraudulently?
There's no liability associated with a violation of that statute, Your Honor. That's why every one of these cases has to fall back on a claim for fraud. I want to go back to the Brewer case, because if you look, we got into this a little bit, but this follows a pattern that exists in this case. Appellants cherry-pick excerpts from cases, provide it to this court, and say it stands for this. But when you look at the case further, and you engage in that analysis, you'll see it supports the trial court's grant of summary judgment in favor of Mr. Black. You look at the paragraph that directly precedes the excerpt Mr. Reynolds cited. It says, although a claim of non-disclosure, that's filling out the property disclosure form, will not overcome an as-is clause, a claim of fraudulent concealment will. So, the trial court correctly determined every single case. I know that you've done your due diligence, but if you look at those again, you'll see checking no on a property non-disclosure form is passive non-disclosure. It cannot overcome an as-is clause. The only thing that can overcome an as-is clause is an active fraud of commission, and that is fraudulent representation or fraudulent concealment.
So in order for this to get past the as-is, the property owner, if he had written, instead of just saying no, if he had written, we've had no problems with the water, then that would have been...
Maybe. Or...
Why is that a maybe?
I don't know if that statement would be enough, but yes, if Mr. Black had written on the property disclosure form, the water is perfect, and there's never been any testing done that would show any elevation of any substances. Yes, that would be a misrepresentation. If the Engers had asked Mr. Black directly, has the water ever been tested and are there any contamination issues of which you're aware? To which he would have replied, no, that is a misrepresentation. Even
answering no under those circumstances? Just
yes,
answering no
would
be an affirmative misrepresentation.
Because it is a direct inquiry, which is exactly what Brewer says.
Okay, so I'm trying to figure this out. So it sounds to me like those are issues of fact, though. And summary judgment.
Those did not happen here.
No, I understand, but what is a affirmative statement? What did the parties know? Because you're saying you dispute a lot of the things that they're saying.
Right, but it doesn't matter. We can assume for purposes of this appeal and purposes of summary judgment that the water's contaminated. That's fine. It doesn't matter. Because what they have to show, because of the as-is clause, is a fraudulent misrepresentation that would be a response to a direct inquiry to which Mr. Black lied. It cannot be checking no, that is passive non-disclosure, or it has to be fraudulent concealment. So in instances like the electrical issue, where the buyer says, no, there's no issue, and then takes measures to try to cover up those issues, that is fraudulent concealment. Neither of those are present here. We know that because the Engers and Mr. Black had no interaction whatsoever with one another prior to the closing of the property. Mr. Enger and Mrs. Enger admitted that in their deposition. We know that the water well was not fraudulently concealed because it was inspected. And 1 month after the Engers moved into the property, they had further testing done. Testing they could have had done before they purchased it if they elected to do that. They didn't. So,
Well, doesn't that go into reasonable inspection as well?
I think that is in the eye of the beholder. Some people are more comfortable with a routine inspection when they're buying a property that is subject to a water well. Others are. I have a water well. I made sure I got a warranty to ensure that water well would not turn bad for a certain period of time, and it was tested.
But I was meaning the case law provides for reasonable inspection, because you're talking about Layton versus Patton, and it talks about a reasonable inspection. They could have performed a reasonable inspection.
Yes, and there's a water well here that is open and obvious, and it could have been inspected, and it is very reasonable to make sure your water is not contaminated.
Your time is up, so if you'd like to wrap up.
Yes, Your Honor. Again, I don't want to beat a dead horse, but the key here is the presence of an as-is clause. When that is present, then the plaintiff or the appellants in this matter must demonstrate that the seller engaged in affirmative fraud. That is fraudulent misrepresentation, misrepresenting the facts to a direct inquiry, just as the Brewer case demonstrates, or fraudulent concealment. The trial court correctly determined neither of those were present here and awarded Mr. Black summary judgment. This court should affirm that. And, Your Honors, I also have pending a motion for sanctions pursuant to Appellant Rule 23. Okay. I won't get into that, but
Counsel,
I wanted you to be aware of that.
Your time is up.
Thank you.
Your Honors, the appellee concedes for the purpose of this argument that the water well is contaminated, which is good because his client testified that he was aware that something in the neighborhood was contaminating the water and the ODNR was trying to identify its source. So it's good that he conceded that because his client stated that under oath. And the law in this area isn't clear. This is the first case that I can find where there's evidence that the person had knowledge that what they were filling out on the property disclosure form was false. And we were able to prove that. This court does not want to be the court that says you can falsify information on that form, just lie and say no, and you know it's false, and get away with it if there's an as-is clause. The court in the 8th District in Nybergen quoted 2 cases from the 6th District and said, an as-is clause does not protect a seller from liability for positive acts of fraud, a fraud of commission rather than omission, such as fraudulent misrepresentation or fraudulent concealment, including fraudulent misrepresentations in a residential property disclosure form. Water quality is so important, it's the first question, the very first question. Are you aware of a problem? He testified that he knew he was aware of a problem. He filled it out no anyway. That was a fraudulent misrepresentation in a residential property disclosure form. For that reason, this case needs to be reversed and removed. Thank you.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of that decision on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you very much.